Hello, everybody, and welcome to the Herrington Carmichael Annual Employment Law Update for April 2025. We are delighted to be talking to you today. It's one of my favourite sessions of the year. It's one of the most detailed sessions of the year, and if you're coming, there's lots to think about and lots to do. I have to start by saying that we are recording today's session, so please be aware that a recording is being made. That recording will be available later if you want to watch us again. And I know how popular Darren and I talking to each other is to watch again, so we'll have that available for you. But before we go too far, I just want to do a formal introduction to Herrington Carmichael. Some of you are new to us and don't know who we are, so let me tell you all about Herrington Carmichael. We classify ourselves as a full-service law firm. We are providing legal advice to both UK and international businesses in relation to corporate matters and businesses of all sizes. We're really good at what we do, is what I'm saying to you. We're a leading firm, recognised by Legal 500 and by the Times Best Law Firms as well. So if you've got legal problems, if you've got legal concerns, we're your place to come to. What do we cover? These are the areas of legal practice that we cover. They're in alphabetical order. If you look down, you'll find employment law, obviously at E, but there's all those other areas covering both business services and individual services as well. So we are continually developing our areas of practice, continually updating what we do, and we classify ourselves as specialists in all of these areas. And I guess it's also sensible to confirm who is talking to you today. So the voice you've been hearing is Alistair McArthur. I am the head of the employment team. I've had the pleasure of being the employment team lead for the last 10 years. And I'm joined today by my fellow partner, Darren Smith, who has been with us for 5 years now, and who is one of my favourite people to present with because he generally tells me that I'm wrong, but I'm hoping today that will not be the case, and we'll see what happens. But the topics we're going to talk about is Darren's going to take you through the Employment Rights Bill update, which is crucial. It is important you listen very carefully to the things that he says about that, because that's where we are in for the biggest changes in employment law in the last 15 years. Added to that is I'm then going to take you through Neonatal Leave and Pay, the Draft Equality Race Bill, tribunal compensation limits, parental bereavement leave, and some case law. And before anybody asks, yes, I will be talking about the Supreme Court judgment which came out last week in relation to the application of the Equality Act to the question of sex. So we'll come back to that towards the end. But without further ado, Darren Smith, I'm going to hand over to you to talk about the updates to the Employment Rights Bill. Go on, Darren.
Thank you. I would never say you're wrong, by the way, never. Great to be here. Thanks everyone for joining us. The Employment Rights Bill. Now, everybody's heard about this, but we have had some key updates earlier this month, which is really useful for us scheduling this webinar today. And that's what we're going to look at. I think we might have some time for questions at the end. If anyone's got an urgent question, you can pop it in the chat box. If I can answer, I will. So look, where are we? Just a bit of context, a bit of background to remind us all. Obviously, the Labour government have been around for almost a year now, just shy, and they came in with their manifesto with a huge sweeping manifesto of changes to employment law. And as Alistair said, it's going to be the biggest shake-up for a very, very long time. So what has happened since the election? Well, we got the draft bill back in October last year, and a lot of the concepts and proposals went out for consultation, which has been happening over the last few weeks and months. And there have been various policy papers and discussions with key stakeholders and the Law Society and the unions and everybody else, and business, of course. And then we've had some updates that came out last month, and that's what we're going to look at as part of a session on this. We can't cover absolutely everything, but there are some things. Like one thing we haven't covered, but I will just say, because I can't help it, is the proposal to extend the tribunal time limits for bringing a claim to 6 months. That will be really interesting and key, and of course will make your jobs busier and ours, because it's going to mean more tribunal claims. So let's get started then with some other key updates on the next slide, if we can. And this is one of the biggest one. Everybody knows this is coming down the tracks. What I do think it's important to talk about is there's always a change, isn't there, between what a government, a party says in its manifesto before it becomes a government. And this has happened here and in some other areas of the ERB as we go through this session. We were told that unfair dismissal was going to be a day one right, and it's still often referred to as that. But let's look at some of the detail of what we know so far, because it's not quite what it seems. It is going to be a big change, but it's not quite going to be a day one right. What we know is we're going to have, instead of the current system, which is where you have to be employed for 2 years before you acquire unfair dismissal rights, that's being shelved. And we're going down to have what the government are calling an initial period of employment. We don't even know yet how long that will be, although it's almost certainly going to be 9 months. That's been in all of the papers and the discussions. So it's probably going to be 9 months. And I suppose the way to look at it is that the current 2-year period is going to become a 9-month period. That's a reasonably decent way of looking at it. But it's not just that, because at the moment, you can dismiss for a reason or no reason at all within 2 years. But in this initial period of employment, we're only going to be able to dismiss by following what they're currently calling a light touch procedure. So there's going to be some process that we have to go through to dismiss someone for performance or misconduct or whatever. Now, it might be that this light touch process is actually just going to involve perhaps a meeting and some written reasons to the employee as to why they're being let go. So it won't be too onerous, but it is a change from now. I've put there 9 months, but 12 months including notice, only because notice needs to be given within the 9-month period. So you could have it then needs to take effect within 3 months. That's the current plan. So, Alistair, there's just a window up on the screen. Might be, there we go. Perfect. Thank you. So it might be 12 months, but we should work on the basis of 9 months to make the decision to dismiss. There's also a review of what compensation might be available for dismissal in that period of time, should it be done incorrectly, the process. And it's going to be, we suppose, a limited amount of compensation, but possibly still compensation. So it's clearly got teeth. We need to make sure we deal with this properly. And one thing that we are also fairly sure of is that this is going to come into effect in autumn next year. There's 2 reasons for that. One is because these laws, these proposals are being changed slightly, but also, frankly, this is to give you all time to get used to it, to deal with any employees you may want to look at their employment between now and when this law comes in, but also an opportunity for you to amend your policies and procedures and contracts and things like that. So you should absolutely be talking to the wider teams, the management teams at your employers about this coming down the tracks next month. But this is going to be a very big change to what we are used to. I just want to finish quickly on this point by saying that we used to have, before 2010 with the previous Labour government, a 1-year period of unfair dismissal. Obviously, the last 15 years, we've had 2 years, and we're going back now to about 9 months. So it's not too different to how it used to be with previous Labour governments. But let's move on, because I'm already way over time and I forgot to put my timer on, which means that someone's going to have to start raising their fists when I go over my time allowance, which I certainly will. Next, fire and rehire. So everybody knows what this is. I've always described it as the nuclear option for when we're looking at changing terms and conditions of employment. It does happen. We know it happens. We see it happening sometimes with local authorities. We've obviously seen some key cases in the press. Next tried it with some of their staff. We all, I think, will be familiar with the P&O ferries disaster a few years ago. But actually, it doesn't happen too often, but it has caused such anger amongst everybody that the government have probably rightly decided to look at this and to narrow it even further than it already was before. And so what is proposed is, well, I without being a cynic, I just want to say again that, the government said they would, outlaw this, but it's now being outlawed apart from when it's necessary. And so when might it be necessary? Well, we're told that the exception might be when a business is in extreme financial difficulty, essentially, but for a fire and rehire happening, the business would probably go into administration or something. So I do think it's probably going to be a high bar. I don't think we're going to be able to say that, oh, you know, we need to save some money and make more profit, so we're going to fire and rehire. I don't think for a second that will hit the bar, but there will still be this ability to do it if you're in serious financial difficulties. But to offset the concession, if you like, that the government have given there, they are doubling, they say, the protective award if you get it wrong to 180 days pay. So often these fire and rehire practices don't involve one or two people, they will involve lots of people. So 180 days per employee is going to be a serious sum of money. So it does have teeth. And also what they've reined back on from following sort of discussion with business and business leaders is the idea of allowing some interim relief applications for employees going through this. So previously it was suggested that you could apply for interim relief, meaning that you could either go back to your job, remain employed, or even just be paid your income, your wage, until your tribunal claim was heard. But that's been dropped, so we can forget about that. And then this is expected to come in sometime next year, so not really too long away. So fire and rehire still there, but very, very difficult to implement. Plus, of course, anybody on this call, especially those of you with household names in your companies, will be wanting to avoid the PR risk of this, because it is a PR risk, a huge risk now for anyone doing it. Okay, let's move on to the next update, which is on collective redundancies. Now, this did cause an amount of consternation in HR and in the law of employment law, in the world of employment law, because we've all been used now for several years, a long time, this idea of separate establishments. So we only have our collective obligations triggered if we propose to dismiss 20 or more staff in one establishment. So if we've got different sites, that would usually mean that if we've got 19 per site, that we don't have to collectively consult. But that they were going to remove that ability, remove the at one establishment rule, which meant that if you were making 20 people redundant throughout the country in different sites in different parts of the business, that would trigger collective obligations, which would be a huge burden on employers and make your jobs, and again ours, much more busy. No retirement here anytime soon. However, again, following discussion with business leaders and the Law Society, and to deal with some concerns that they thought businesses might, some things they might change to try and avoid this, they have removed it. But they have come up with something else, which is to say that your collective obligations will be triggered if it's 20 or more in one establishment, or if some other threshold is met. Now, the reason that's vague on the slide is because it is still vague at the moment. It's going to be a number of employees, or potentially a percentage of total employees, where it's more than one establishment, and that is when our collective obligations will still be triggered. So just to summarize, we've still got the 20 or more in one, but there's also going to be another threshold that we'll need to consider, that we don't know quite what it is yet when we come to do these redundancies. So it's really important, if you're planning any kind of collective process, either try and do it now before this comes in. Once this comes in, and we'll update you with the more detail when we get it, once it comes in, we need to make sure that neither of the two triggers are triggered, otherwise your collective obligations will be set out. Also, just some other things. Again, there is a doubling of the protective award. So if you get it wrong, there's 180 days pay per employee, which is a lot of money. And also, it's suggested that there might be a doubling of the collective time periods, the minimum time period. So at the moment, we have 30 or 45 days, depending if it's more than 20 or more than 100 people being made redundant. It's suggested that especially the 45 days might go to 90 days, so we'll keep an eye on that. Separate consultations are allowed, so you can have different consultations in different parts of the country. And again, the interim relief protections, which were suggested to be put in place, have been removed. So that will be useful for employers to know as well. Okay, let's go on to the next exciting topic, which is a big one. Feels like it should have more than one slide. So what is this? At the moment, there are different parts of government and different agencies that look after different things relating to employment law. So, for example, you have like the Gang Masters Authority that looks after modern slavery, and you have HMRC that looks after the minimum wage, and you know, where those laws are breached, then the particular organisation, agency, part of government that look after that bit will come after you. So it's suggested through the Employment Rights Bill to uniform all of that, to remove all of the splitting out of different agencies, different responsibilities, and to bring it all under one roof of an agency called, as you can see, the Fair Work Agency. Now, one of the concerns I've read about this is the budget. There is no money ever anywhere for anything. And this is going to cost money to set this up and to run it. And for it to be effective, there will need to be money invested into it from government. So we wait to see where the budget comes from for this. But what we're being told is in time, and there's no 2026 setup for this, like some of the other parts, this could be some time away, but there's going to be a Fair Work Agency set up. And they'll do a whole bunch of things, including, as I say, modern slavery, HMRC, you know, where there's a failure to keep adequate records of holiday pay, the Fair Work Agency will come in. They can enforce decisions. They can give you a penalty of up to 200% of whatever you know, underpayment there's been. Where employees don't want to bring claims themselves, the Fair Work Agency will be able to bring a tribunal claim on the employee's behalf. They'll be able to recover enforcement costs. They'll be able to send enforcement officers to your business dwellings. They will have teeth. They will be able to do a lot of things. Now, everybody on this call, of course, will be ensuring that they meet the national minimum wage and pay the right amount of holiday and keep the right records and everything else. But it is really important to know about this, because this is a big change that is happening. Although, as I say, at the moment, no obvious timeline for when this will be. Partly, I suspect, because of the huge cost and admin burden of extracting it all from all the various agencies and bringing it under one. Right, no questions so far. Never know if that's a good thing or a bad thing, but let's move on. What else is changing? So as we move now to family rights, here are a couple of changes which are really important, because we first got something called the miscarriage bereavement leave. So at the moment, if there is a baby loss before 24 weeks, then there's no automatic right for time off. Now, many employers will perhaps offer time and maybe even pay. But in terms of the statutory law, it only applies if a baby is lost after 24 weeks. And so this miscarriage bereavement leave is to cover the wider remit of any losses of babies prior to 24 weeks. And this will be 2 weeks of bereavement leave. So 2 weeks of statutory leave away from work that you will be entitled to, both the mother and a partner. It's not paid. That was a disappointment from those that campaigned for this. It's not paid. Although I always think with things like this that the statutory law will put the line in the stand, you know, start something, employers then get used to, well, we have to do this. And then in time, if not straight away, employers may well consider enhancing the statutory minimum. So you may consider in your organisations that you're able to offer even a statutory rate of pay for bereavement leave, but it is a step in the right direction. So that's something that's going to be really important for those that this affects. So that is there. And another one is a further strengthening of dismissals and dismissal procedures for women and individuals coming back from family leave. So you may know that for a very long time we've had this idea that when you're on maternity leave, and you're made redundant, you have an automatic right to a suitable alternative role if one exists. So that's an enhanced right over everybody else. That was then extended for a much wider protected period, 18 months. So that protection is there now. But the proposals to go even further and to essentially ban any dismissal of, in this case, with the slide, I said, a woman coming back from maternity leave for 6 months after they get back, except there is an exception for certain circumstances. And I hate to sort of roll your eyes and you know, I just don't want to be a cynic, but it just seems odd because this is, for me, another example of something that was said in the proposal, and then where actually when you look at the detail, it's not quite what you think. We don't know yet what the certain circumstances will be. Presumably, it will be redundancy, and surely some sort of misconduct, gross misconduct, because it feels odd to think that you won't be able to dismiss somebody for clear gross misconduct. So I do wonder about the effect of this and whether it's quite what it says on the tin, but it is a further protection for women coming back from maternity leave and others coming back from family leave of similar ilk, like shared parental, etc. So that is of interest, and that will be coming in, and then there will be a process that will be told that we'll need to follow as well if we do need to dismiss someone. So what do we have next? 0 hours contract. Now, which side of the fence are you with this? There are two sides of this fence, because on one side, 0 hours contracts are the devil. They are hated and detested by everybody. They're just there to take advantage of the vulnerable and the low paid, and it's awful and they should be outlawed. And that's very much some of what you heard in the run up to the election from the Labour Party. But I think it's right to provide some balance. Now, I'm not saying that people aren't taken advantage of and that people don't need protections. They are, and they do. But also 0 hour contracts also provide a really useful way to earn money for lots of people in particular sectors. I also find that there are a certain group of people now coming through the generations where this idea that you have sort of one job, you know, one career your whole life, is sort of going a bit more. Some people seem now to be interested in having, you know, maybe 2 jobs for their whole lives. So suddenly, you know, in different sectors. So suddenly 0 hours contracts, they can be useful for some, but the government have decided that they need additional protections, and here's what is being proposed. So the first is a right to guaranteed hours, and what this means is that if you have been engaged for a period of time, then you have the legal right, or you will have the legal right, to be offered a contract with those minimum hours. So we think probably that reference period will be 12 weeks, although we wait for confirmation. So that means that you will then be offered those those hours that you've worked in those 12 weeks. If you want it, the guaranteed hours will be there. Of course, you don't have to accept it, but that is what will need to be offered to the worker. Next, you've got reasonable notice of shifts and compensation for cancelled or curtailed shifts. And I think this has got to be a reasonable one, because one of the criticisms that you hear often is that somebody will plan for a shift and they will, you know, work out their income and maybe turn down other work because they've got a shift booked for tomorrow. And then they wake up in the morning and the shift has been cancelled and they lose out and can't replace that income. So I think that it is, this has got to be a reasonable protection, that there's going to be, you get reasonable notice of shifts. Now, again, you don't have to accept the shift, but if you're offered one, you've got to be given reasonable notice and not penalised if you can't, you know, jump when someone clicks their fingers in 20 minutes to get down to wherever you need to be. But also, if you're booked for a shift, if you like, and then it is cancelled or moved, you will be entitled to compensation. So look, I think that's reasonable. But as I say, I want to end by saying that I don't think 0 hour contracts are, you know, as bad as we're told, but we recognise that there are improvements that can be made, and hopefully this will be the start of that. Right. Next, we have just on extension of that point. You can, if you're part of a union, if you've got a collective agreement, you can opt out of those rights if you want to. And so perhaps this is as a result of the government listening to those that say that 0 hours contracts can be very useful and beneficial for some. So you can opt out of all of those extra protections if you wish to, in terms of guaranteed hours and notice of shifts. Okay, if anyone that wants to get excited for Alistair's return, it's not far away. But before that, we're going to look at statutory sick pay. So the changes that are proposed here, we think probably later this year, will be that instead of waiting for 3 days before you become entitled to statutory sick pay on the 4th day onward, it's going to be from day 1. So that is a change. That's a big change. Another change is that at the moment, if you don't hit the qualification threshold, if you don't hit that lower threshold, then you don't get to qualify for statutory sick pay. But that is going to be changed so that SSP will apply to those lower earners. But if you don't qualify for full SSP, then you'll get 80% of your average earnings. So it's going to get whichever is less. And the government thought that was a fair balance between, you know, protecting staff, but also recognising cost on business. So SSP is going to apply sooner and to more people. So this is a big change. Now, again, as ever in life, there are two sides of this argument, because on one side, you hear the obvious: costs for employers are going to rise. Employers have been you know, there are a lot of costs this year. We're coming in this month with the NI increase in particular. There are costs going up, there are pressures. So any cost for employers is often not welcome. And the suggested cost is at least 5 million a year that this is going to cost those people, those organisations that employ people. So that's bad. But on the other hand, there is information and research that suggests that if we can look after people that are sick, if we can intervene earlier, then people will get healthier earlier and will be able to work harder and for longer and have less sickness overall. And that could be predicted to bring in billions of pounds for the economy. So look, there are two sides of the argument. We have to see which one ends up being right. Hopefully it's the second one, because that's what we want. But what you need to be doing is looking at your policies now and making amendments. Now, looking at the clock, I'm going to move straight on to the next slide. Which is, drum roll please, we're all excited to find out.
It's me, Darren.
Sadly, I'm done. So
it's me. You're not quite done, Darren. You're not quite done. We've had a few questions on the ERB stuff, and I was going to throw those at you very quickly. You've got a moment to answer and ponder on these.
Gosh, so, I need a spotlight on me.
In a couple of questions, let's just reflect back on collective redundancy. We've been asked the question as to whether the thresholds are now being influenced by European views in relation to works councils. Do you have any opinions on that?
Well, I mean, probably not. I don't know if you've got a different view, Alistair. I don't think so. I think you do look at other countries, especially in Europe, although less now following our detachment of our relationship, to see what happens over there and whether we should be protected. And obviously, a lot of organisations will have these global reaches and European reaches, but I don't know. And there are so many differences in with the works councils in the different countries that I'm not sure there's sort of one approach that makes sense for us to follow. So I don't think so. What do you think?
I'm not sure either. I mean, I think we see European influences and foreign influences in lots of areas of our employment law, but in relation to collective redundancy, I think it's now becoming very much of a UK principle. That's what I'd say. And if I pick up another one on the ERB, is the 0 hours contracts, Darren. In terms of shift cancellations, is that only in relation to 0 hours contracts?
Yes, I think so. I think it's just in relation to 0 hours contracts. I mean, we wait to see about any changes, but that's my understanding.
And what if the work demand changes and the shift's no longer required? Would that cancellation still be there?
No, there's no suggestion in the guidance or the notes that, you know, there'll be what would you call it, a get out clause. In some of the other changes that I've talked about, there are some exceptions of, you know, in exceptional circumstances or in limited cases you can do this thing. I've not seen any suggestion that there will be a get out clause for you don't have to pay compensation for a cancelled shift. So if that is the case, which I think it will be, then it's going to be onerous on the employer to ensure that if you are offering a shift out to someone, that it is something that you can honour. So therefore, you'll be wanting to make sure of that before you send it out. And if there are last minute changes, I think you're going to have to suck it up.
I think I agree with you, and I think that's the problem, isn't it, for those 0 hours environments getting used to that changing culture. Thank you, Darren, and thank you to those who are putting questions into the chat box. Please keep chucking those in. We will do our best to pick those up as we go along, but we are getting quite a few now. So what we'll try and do is after the session, we will produce a generalised summary Q&A document responding to those as well. So if you've got any as you're thinking as we're going along, throw them in. Some of them which we've asked, I will pick up on in the next half of the session. And I'm now going to move on to the other updates and the other things outside of the ERB, because there have been other things happening in the world of employment law. And I'm going to talk about legislation first, and then I'm going to move into some case authorities. So let's pick up some legislation. The first one is the Paternity Leave Bereavement Act of 2024, which came in last year. So this is already good law. Many of you know the right to paternity leave as it was. It was the right for fathers predominantly, or people taking paternity leave who had 26-week qualifying service, to provide additional leave to care for children and their partner. What's changed is that that's now been enhanced to deal with situations where there is bereavement, and that could be either the child or the mother who has died during childbirth. Now, in this situation, this is now going to be a day one right. It's going to be a really essential right for parents in this situation, because as you can imagine, this is a very traumatic position for people to be in. And from our perspective, we find that employers are already giving this leave right anyway. This is not a new thing. It's just a codification of things that employers are already doing. And it will, interestingly, though, create the right for parents to have kit days during this paternity leave. So if there's a bereavement, theoretically, the bereaved parent can take this leave and they can still come into work for keeping in touch days without the leave ending. What does this mean for you as employers? It means that your paternity leave policies need to be updated. You need to go back and open those policies up, update them, be clear it's now a day one right, be clear there are bereaved rights here. And generally, we see that employers actually go beyond the statutory regime, so that this is not paid at a basic salary level. It's actually paid at a full pay level and paid at a period of time of generally a 2-week period, in order to give that support to parents who've lost a child in that situation. This is the area of law which will be adapted in relation to miscarriage bereavement as well. Darren's mentioned that already in the ERB update. This is something which will be adapted in time. It could happen at any point in time. We haven't got a clear position as to when it will happen. The government said in March that they were going to bring it in. We think it could happen anything within a couple of weeks, potentially a couple of months. If it does happen, please do sign up for our employment law updates. We will be giving an update on that if and when it happens there. Let's move on to neonatal leave and pay. So this one came into effect in March. I know this is a big change for lots of businesses. It is the situation where we now have to give a new family leave right, which we didn't previously have as employers to give. It's the idea now that an employer must provide parents with up to 12 weeks leave and pay where their baby is receiving neonatal care. It's not just an any old right for parents. The child has to be within neonatal care, and it only applies to particular eligible groups. Whenever I've had this situation before, it is something which employers just do. Again, I've never known a situation where I've had a client ring me up and say, hey, we've got a child whose parents are, a parent whose child are receiving care. We want them to still come to work. I think that that's been something which has been it just doesn't happen, because we're all human beings. We all want to make sure people are looked after. You will see at the bottom of the slide that we've got a distinction between tier 1 and tier 2. This is where this legislation becomes really complicated and really quite dry as well, because a tier 1 element of neonatal leave is where the leave request is being made within 28 days of the birth of the child. The tier 2 is where effectively the request is being made within the 68 weeks of the baby's birth. And there are different notification requirements between tier 1 and tier 2. These are hugely complicated. And if you want to know more about it, please do let us know, because we've got a whole session recorded already in relation to neonatal leave and pay. So if this is of interest to you, I can share a session which Matt Jenkin and our team did going through those requirements. But in essence, a tier 1 situation, the parent needs to give notice before the start of the working day or as soon as reasonably practicable after that. Or in a tier 2 situation, they have to potentially give 15 days notice of it. But this is only in relation to those eligible people. So it's only employees themselves, the baby's parents, the intended parents, or the partner of the mother who can qualify for it. And in most cases, we're finding that employees are reluctant to take this leave. And the reason being is it's at the lower statutory payment level. And because it's at the lower statutory payment level, we find that most employers are actually enhancing the leave now. And I know it's a question being asked, what is happening on the ground is that most employers are enhancing this right so that there is an allowance of a paid element in relation to neonatal care. But really, this is for you as an organisation to decide, what do you want to do, how far do you want to go, and what do you want to pay. And we would encourage you to be now putting in place neonatal leave and care, leave and pay policies. We have those available to discuss with people if you want to talk about how you frame those. They are very cumbersome and very lengthy, given those very extensive notification requirements that I've mentioned. So please do let us know if you're interested. The next one I'm going to talk about is something which is on the horizon. It's coming. The reason we're talking about this is the government started consultation on these issues in March and are closing that consultation in June. So what the government is looking at is an extension to gender pay gap reporting in relation to disability and race pay gap reporting. And this is the draft bill that's sitting there. It's going to work in exactly the same way as gender pay gap in relation to the reporting requirements. The situation is that in a gender pay gap position, employers have to publicise a report for where they have more than 250 employees. The idea will now be they have to also publish ethnicity and disability reports in the same way. I can hear some of you almost audibly breathing a sense of, oh my goodness me, how on earth do we do that? Because in many cases, ethnicity may not be known or disability may not be known. So the government is putting in effectively a voluntary reporting process, which will be there for employees to decide whether they want to report their ethnicity and disability or they want to opt out of doing so. And effectively, as a business with more than 250 employees, you'll have to give employees the opportunity to report their ethnicity or disability or opt out, and then you would report on the data off the back of that. The other audible sigh we normally get on this is, how do you actually report on this data? Because it's going to be all over the place, depending upon the levels of ethnicity within an organisation and the levels of disability within an organisation. And this is all to come. This is where the consultation is taking place. And how do you actually report on this and make that data credible in order to be something which can be relied upon later? And really, I think the government are just looking at putting some pressure on businesses to look very carefully at what the pay differentials are in this ethnicity and disability space, so they try and shorten that gap. The difficulty is, if you look at the data, it has not been successful in relation to gender. So I'm not going to hold my breath over it being successful in relation to race or disability either. Now, if I just move on very quickly, going to talk about the increases to statutory payment levels. These happen every year. The government were very late publicising these this year. We only had these for a couple of weeks. And if anybody's started any redundancy consultation in March, you'll know that when you started that redundancy consultation, we didn't know the week's pay level, which was really hard when you were consulting with people about what was the level of pay in in the calculation of statutory redundancy pay. But we do know now is £719. So on the slide there, we've got the new minimum wage levels, the new statutory sick pay levels, the new levels in relation to family leave rights, and then the levels down there in relation to weeks pay for redundancy pay. The same amount in terms of the basic award for unfair dismissal, because they're calculated the same way. And the compensatory awards, that's the maximum capped compensation for unfair dismissal, which is the lower of either the £118,223 or the 52 weeks gross pay. So I've cantered through those, and I'm going to move on to some influential case authorities, because this is where often for you find the sessions are really interesting. We want to just pick up on a few of the very key cases. So I'm going to start with Higgs and Farmer. And the reason I'm starting with this case is because this case was publicised in March. This is the case which you will have probably seen in the press, and it relates to the conflict we have in employment law between views on religion or belief and sexual orientation views. And in this case, Miss Higgs was a pastoral administrator in Farmer's School. She put a Facebook post out there in relation to her personal belief in relation to the conflict or potential conflict between Christian faith and sexual orientation teaching, which was taking place in the schools. This was a generic post rather than being about Farmer's Schools itself, but it was conveying her own personal belief on the issue. Now, I did think about putting the post on the slides, but actually you just need to know that this post was nothing which was necessarily unusual as a view that is held in society. It's just that some people in society may also find that post to be offensive. Having said that, the school had a complaint from a parent because that parent found it offensive. They went through a disciplinary process with Miss Higgs and they dismissed her because of it. And she then claimed that that active dismissal was an act of direct discrimination and harassment. The Employment Tribunal, when the case came to it, they found that dismissal was fair. The case then went through the Employment Appeals Tribunal and went up to the Court of Appeal. Now, the Court of Appeal sat there and made a very well-reasoned judgment in relation to this issue and how fundamentally in society there are differences of opinion, and we have to be prepared to tolerate differences of opinion, provided that opinion is not in itself objectively objectionable. So what I'm saying by that is something was not, by looking at it from an objective lens, something which would be objectionable to broader society. In this case, what was put out there could be offensive to some people, but looking at it objectively, it wasn't going to be objectionable to everybody. Now, this gets into a really hard position for employers to now apply, because you find yourself in a world of actually having to look very carefully at what is said and whether that is something which would in itself warrant dismissal, or is actually just a conveying of a religious belief or a protected belief. In this case, the threshold was not met. So therefore, because the dismissal was in relation to the post, it gave rise to a discrimination claim and a harassment claim. This is where you all start to sort of feel quite anxious about this, because we do see things in society which are potentially going to be on this line. And how do you as an employer make those judgments? Having looked at the case, I think Farmer's School were too quick to react. They responded too fast. They didn't follow a proper process. They didn't reason very carefully as to why perhaps that post was not acceptable to them as an organisation. They didn't have a codified view in relation to their ethoses, that's a bad word, in their ethos, about how they as an organisation felt their employees should behave. And they imposed their own subjective views and responded to the parents' views rather than necessarily looking at it from an objective stance. It's important that if an employer is going to dismiss for these things, they do objectively reason through their responses. They do follow clear processes. It is possible to dismiss for these things, provided you've done it properly and you've objectively justified it. But actually in this case, because the post was of a lower threshold, it wasn't so offensive to broad sections of society, it was going to be very difficult to dismiss fairly. And this, I have to say, is one of those situations where you have to take specialist legal advice. It's something which we'd be very happy to assist with. And I know that in cases like this, we all sit around a table and we assess things as to where we think they sit and what is the right way to address it to avoid the risks. Now, let me move forward onto another very, very contentious and hot topic in the world of law and in the world of employment law. This is the case which I mentioned at the start, which is the For Women of Scotland versus Scottish Ministers case, which is the Supreme Court's decision in relation to the application of the question of sex under the Equality Act 2010. Now, the decision is very lengthy and it's quite complicated. The simple answer is that the question of sex within the Equality Act will now be determined on the basis of biological sex, necessary rather than transgender sex or where a gender reassignment process has taken place. The court is very, very clear that this change in the law is not intended to undermine individuals who are transsexual. The law already protects individuals that are transsexual through the Equality Act provision. What the court does say is that effectively where the application of sex in relation to the Equality Act is determined, that is now to be determined in relation to biological sex. Now, you're also thinking, okay, that is a tough decision necessarily for people who are transsexual. And I've seen lots of commentary from transsexual colleagues in the legal sector talking about how this now impacts upon them and how they feel vulnerable as a consequence of that. And I have to say, I find that quite hard to read on their behalves. And the EHRC are now trying to tackle very closely the guidance in relation to these issues. The guidance from the EHRC has been publicised on an interim basis. It is not final guidance, but it's talking about the access to facilities and services in relation to where biological sex is important. And you will have seen the BBC News articles about the EHRC saying that if the NHS does not apply this correctly, they will pursue the NHS for this. And I find that quite a hard thing to get right. The EHRC guidance has been both criticised and welcomed in equal measure. It's hugely controversial, and it's something which you as employers have to tread very, very carefully with. That's particularly the case for those employers in the healthcare sectors or where services are determined based on sex, because now the idea would be that you would have to apply that based on biological sex rather than transgender sex. Now, what does this mean for all employers is that you do need to think about this. You have to think about it from the context of your transgender colleagues and how are you going to accommodate them? Because the theory runs in relation to this now is that you would not make things available to them any longer, which you had previously made on a transgender basis where that applies to sex. And being blunt, this relates to toilet facilities. It's something which is very, very hard. It's something which you need to think about very carefully. And the idea would be that effectively you would either turn a blind eye to this legislation, this case or judgment, which would be a bad thing to do, or you would need to look at how you apply facilities so that they are available for colleagues who are male, female, and transgender. And this is something which becomes a very difficult thing to get right. You inevitably run the risk of offending somebody, and you need to tread very, very carefully in terms of doing so. The issue which now, the question we always get, and I suspect someone's writing it literally as I'm speaking, is, do I think the law is going to change? At the moment, we wait to see what the EHRC come out with when their guidance comes out. And I have to say, I was a little bit disappointed that the EHRC weren't quicker with their guidance and haven't been more on this, because this has been a judgment which has been waited for some time. And you would think would be planning in the background about what would be the outcome if this was the decision. But no, they haven't. They've come out with interim guidance, and we now sit and wait as employers. There is no time in the current government legislative framework to introduce this. There is no, as I understand it, appetite from the government to go backward and change the law back the other way. And this is such a difficult issue for any political party to grapple with. I don't think this is going to change. I think this is going to stay as what the law is now until there is political pressure on governments in the future and in different parliamentary sessions to come along and change it. It's so controversial, though. I can just see them sitting back and going, I don't really want to touch this right now. I want to make sure it's something that we don't talk about and where actually it just goes away as an issue. I do know, though, that in the transgender movement, there are huge concerns on this, and there is a large level of political lobbying taking place. And if this is something which is important to you, I would encourage you to lobby your MP, because that is your route now to come back and to challenge this decision. I'm sure there'll be other questions on that. I'm sure there'll be other people who will have things that will want to talk about that. We'll be very happy to answer anything we can do, but I do stress that this is something which is very much in the process of awaiting guidance, and keep your eyes peeled, because that will be something which will come. And as I've said, we will have further updates on this as soon as they are available, and we can do more for you. Right, the final case is the Johnson and Bronshield case, and this one is interesting because it deals with the issue in relation to disability discrimination in relation to the issue of menopause. Now, in this case, Bronshield were trying to prevent changes to their working environment as a consequence of Miss Johnson's requests to help and support her in relation to her menopause. The situation was such that she had requested to take Fridays off and to change her working arrangements in order to provide caring responsibilities and to assist with her menopausal symptoms. The business rejected those and argued business need requirements, and she resigned in response to that and pursued claims of disability discrimination and constructive dismissal. In advance of the hearing, the employer accepted that Ms. Johnson was potentially disabled as in the terms of the Equality Act. And this is a good reminder to employers that that menopausal symptoms can meet that threshold in relation to the question of disability. And that is whether it's a physical or mental impairment which has a substantial and long-term adverse effect on normal day-to-day activities. And long-term here, we're talking about for more than 12 months. And actually, it's important that you look very carefully with colleagues who are going through the menopause as to whether their circumstances are such they would meet that threshold in relation to being disabled. If they do meet that threshold, they have those disability rights that then apply. The tribunal in this case ruled, however, that actually the requested changes were not disability discrimination. The reason for that was because anybody who was not disabled would have had the same adjustments declined. So a woman who was going through the menopause and didn't meet the threshold would also have had the same adjustment request, but they would have been declined in the same way, and it would have made no difference because they were not disabled themselves. And I think that's interesting because it's a good reminder that actually to get the protection of the disability legislation, you have to meet that threshold of demonstrating that the disability, the person would have been treated different because of their disability. In this case, though, Bronshield did deal with it quite badly. So there was still a breach of the implied term of trust and confidence, and the constructive dismissal claim did succeed. So it's a reminder that this is a developing area. We're seeing lots of clients who have got menopause policies now in place. And it's an encouragement to you who do not have menopause policies to think about how would you work with colleagues going through this and to help and support them in terms of the adjustments that they need in the workplace. Right, so we have got a very brief time for some questions now. So if you do have questions, please do chuck those into the chat box, and we will see if we can pick up on those as we go. There was a question, Darren, in terms of actually before I ask you that question, let me just flick onto the slide because I think this slide is much more interesting because Darren and we like to have friends on LinkedIn. And on the slide now in front of you, you will have 2 QR codes for Darren and I. And if you pick up your smartphone and you open up the telephone app, you can go straight to our LinkedIn profiles and you can be our friends on LinkedIn. We like to gather friends on LinkedIn. It is one of our key mechanisms for giving you updates and communicating with you. So I'll leave that slide there in a minute. On the next slide, I've got a QR code to go to our updates as well. So you can sign up for our updates too. If we just go back to 0 hours contracts though, Darren, because we have a question on those. Is there a time frame, do you think, that would be considered reasonable to cancel shifts or provide compensation shifts? Or is there any guidance which you think there would be in relation to that?
No, it's all subject to thoughts and comments. So, I mean, you could write to your MP, but I don't suppose you worry that much about it. There isn't. I think it's designed to deal with the very last minute cancellations. And so, yeah, I'm really just speculating, but surely a 24-hour, a 48-hour notice would be reasonable. But I don't know. We don't know. When we do know, if you're signed up to our mailing list, we will let you know. Alistair, I hate to say it, but you're on mute.
Am I back? Can you hear me now?
You're back. I can't believe you made me say that. I cringed as I said it.
I'm not. I wasn't actually on mute. My microphone has died. So there we go. You've got. Hopefully, it now works a bit better. That's good, though. We thank you for pointing it out. I think I was going to say to you, you were talking about 0 hours contracts. I think there's an interesting comparison with holiday and the amount of notice you have to give to request holiday. And I can see the time periods being similar in the context of the length of the shift and giving an equivalent amount of notice compared to the shift length. I think that could be the way that we end up going.
Yeah, it could well be.
We've had a question about the transgender judgment, unsurprisingly, in relation to the application of the judgment to women's only facilities and whether that will now have to be determined in relation to biological sex or not. And I think this is really where the judgment is so very, very difficult, isn't it? And I don't know whether will have difference of views to me, Darren, as I answer the question. I think it will be important that organisations look at the EHRC guidance very closely when it is fully publicised as to what they have to make available in a women's only facility, as to whether that is to be determined on biological sex or transgender sex. But if I take the strict reading of the judgment as it is now, the access to women's only, in inverted commas, would be in relation to biological sex, not transgender sex. And the question then would be whether the organisation needs to provide alternative facilities for somebody who is going in a transgender situation. Would you agree with that, Darren?
Yes. So the Health and Safety at Work Act says that you must provide single-sex facilities, which could just be a toilet, a unisex toilet, but with a lockable door. Of course, that act is decades old, and so in applying now this judgment, it's saying where you provide a single-sex facility, that should be sex based on your biological sex. I would just add that I don't think it is for users of toilets in workplaces or elsewhere to challenge other individuals in that toilet. I don't think it's for, as they say, service users to challenge anybody, because that would be very difficult. But I think where there are concerns, if you have concerns, under this new legislation, under this judgment, then it should be reported to HR. So it's a very difficult thing. But where you do provide a single-sex facility under this judgment, it will need to be biological sex, and that's what the interim guidance has said as well.
I think that's right, and I think that's a really difficult issue for employers to grapple with. You'll notice I flicked on the slide, so we've got now the QR code to sign up for our mailer. If you don't receive our mailer, you can sign up here, and we give weekly updates in relation to all issues on employment law. But I've got one more question which I'm going to answer. We're down to our last question, our last minute, so I'll see if I can cover this one quickly. We've had a question about reviewing contracts and how one of the participants here is currently going through the process of reviewing their contracts. And is there anything we'd recommend in preparation for that as part of the changes? And I think my view, Darren, is, I don't know whether you disagree with me, probably you do, is that there are things certainly in the latest update to the ERB which you do need to look at quite carefully if you're going through contractual change at the moment, particularly around probation periods and the initial period of employment. I think I'd be looking very closely at that. For me, though, I think the bigger thing for those on this message call now is if you've not reviewed your contracts and you don't have people on an up-to-date contractual terms, I would be doing that right now. I'd be getting your employment contracts out. I'd be dusting them off. I'd be checking them, making sure they're up to date, making sure all your employees are on up-to-date contracts, because of the law on fire and rehire coming and the fact that you won't be able to potentially change those contracts as easily later on. And I think it's a time now in the next 12 months to be looking at this, keeping an eye on the updates to the ERB, seeing what's coming, keeping the contracts up to date more generally, but getting the contracts changed before the changes come into place. Do you agree?
I do. Yeah, I've got nothing to add. I think that's right.
Excellent, thank you. I think that's a good point to draw a line. It's now 1 o'clock exactly. As I said, what we will be doing is we will be sharing a copy of this update in the video form. We'll be circulating the slides to you, and we've got a list of the questions that were asked as well. So we'll be trying to do a quick, brief Q&A document to share around. I think the last thing to say is thank you all for coming. It's been a real pleasure talking to you this afternoon. It's been a pleasure as always talking with you, Darren. And lastly, I think is to wish you all a lovely rest of your day. Go and enjoy the sunshine. Thank you very much.